Welcome, everyone. This is the panel on workers and their unions. My name is Kent Greenfield. I'm a professor at Boston College Law School. Now, most of the cases on the Supreme Court's docket in any given year are not the likes of Windsor, Shelby County, or Fisher. They get the headlines, of course, and rightly so. But most of the court's caseload is dedicated to answering questions, resolving circuit splits in various small pockets of the U.S. Code. 20 years ago, I worked on a case about the statute of limitations of the Worker Advanced Retraining and Notification Act. Yeah, I'm sure that's in all your case books. That's the kind of case that really fills up the docket in most years. In fact, in this year alone, even if all the remaining cases are split, 58% of the total cases this year will be decided by unanimous vote. This is from Garrett Epps, one of the most fastidious court watchers we have around at the ACS. So given that, if you had looked at the January argument list, you would have been, people would have understood if you thought that Harris v. Quinn falls into this group. The question presented appeared to be exceedingly narrow and specific. Whether home health care workers in Illinois, paid for by Medicaid, are state employees. If they are, then a union representing them, state employees, would be under a duty to bargain collectively on their behalf, and the workers would be required to pay their fair share of the cost of such union representation. Now, the case arose originally when some healthcare workers, covered by the collective bargaining agreement, challenged the mandatory union fees as a violation of the First Amendment. Now, the Seventh Circuit decided the case in a terse, unanimous opinion. It was an easy case. For nearly 40 years, since the Bood v. Detroit Board of Education, the law has been settled that public employees may be compelled to support legitimate, non-ideological union activities, quote, germane to collective bargaining representation. It is the quid pro quo of labor law. The unions are under a duty to represent all employees in the bargaining unit, and in return, the employees are prohibited from free riding. So it was an easy case, decided unanimously by the Seventh Circuit, turning on elements of state law. So why did the court grant cert? Something evil this way comes, right? Something must be up. And some court watchers are saying that Harris could be the sleeper case of the year, and not for good reasons. It may be the decision, in the worst case scenario, that makes the so-called, misleadingly called, right-to-work laws constitutionally required for public sector employees. So this morning we have 4 distinguished panelists to discuss what is going on in Harris and its potential implications. Starting at my right, we've got Catherine Fisk, who is the Chancellor's Professor of Law at the University of California Irvine School of Law and one of the nation's leading experts in civil rights and labor law. To my immediate right is Nicole Berner, Associate General Counsel of the SEIU, also the lead counsel to SEIU's 1.2 million healthcare division. To my left is Sarita Gupta, who's the Executive Director with Jobs for Justice. And to my far left, Scott Cronlund, partner at Ashler Burzon, who is counsel to SEIU in Harris and won the Seventh Circuit case below. So during the next hour and 15 minutes, we're going to talk about the implications of the case, educate ourselves about why this case might be important, and we'll promise to leave about 30 minutes at the end for some questions and answers. Let me remind you to silence your cell phones. And I invite you to, by the way, to read the panelists' bios in the program, now decriminalized. So you can take a look at those. They're very distinguished people, and we're honored to have them. So Catherine, let me start with you. Can you explain the lay of the land legally as Harris gets to the court?
Sure, it's a pleasure. And it certainly beats talking about a Supreme Court case that hasn't been decided and trying to speculate what the court is going to do. There are a lot of labor lawyers in this room, and so some of this is going to be familiar to you, but it's pretty technical. It's one reason why I think people don't realize how important Harris is going to be outside of our little world of labor law. Under federal law governing the private sector and state law, which governs state and local labor relations, unions are chosen when a majority of the workers in a workplace or other appropriate bargaining unit select a union they are chosen to be the exclusive representative for all employees in that unit for purposes of collective bargaining. In that respect, it's like a legislative election. You vote for your member of Congress, one person then represents the entire district, both those who support that representative and those who do not. The union, by virtue of its position as the exclusive representative, owes a duty of fair representation to all employees in the bargaining unit. What the duty of fair representation means is that the union has to negotiate a contract that is fair to all employees, both those who support the union and those who do not. And the union further has to enforce the contract on behalf of all employees, not just those who are its members. Nobody is required to be a member of the union. You don't have to join even if you are represented by the union. But nevertheless, the union owes a duty even to its non-members who refuse to pay dues as members pay. In about half of the states have enacted legislation, the so-called right-to-work legislation, which is actually not appropriately named. It's really the right to free ride or the right to shirk, which allows people who choose not to join the union to pay exactly zero for the free legal services that the union is obliged by law to provide. So I'm not a union member because I'm not eligible to join a union as a university professor. But if I had one, the union would negotiate a contract for me. Walmart employees don't have anybody to negotiate their contract for them. Walmart just gives it to them. Non-members get a contract negotiated for them, free legal services. Non-members also get the contract enforced for them. Almost every union contract prohibits firing an employee but for just cause. And when an employee is fired arbitrarily or unfairly, the union has the obligation under the contract and under the state labor relations statute to bring a grievance on behalf of that worker. None of us gets free legal services, but non-members do in right-to-work states. In the other half of states, the states that have not enacted right-to-work legislation, the union can require those who choose not to join as members to pay what's known as a fair share fee or an agency fee. The fee is the non-members' pro rata share of the costs that the union incurs in negotiating and administering the collective bargaining agreement. In a long series of cases that the Supreme Court decided, there's been a whole body of law trying to decide what fees unions can charge for those who choose not to join the union, even though they are represented by it. And as Kent mentioned, the union can charge germane fees to cover the cost of the germane activities, that is, germane to the union's role as collective bargaining representative, and cannot charge non-members for things that are political or that are not germane to collective bargaining. The problem with this, and there are a whole slew of cases trying to draw that line between germane and non-germane. The problem in right-to-work states is that unions who are forced to provide free legal services for people who won't pay for them essentially are forced to subsidize services for non-members. And of course, unions get money only from their members. So what this is completely unprecedented anywhere else in the law, that a private membership organization is required by statute to provide free legal services to people who are not its members, and that the cost of those free legal services are paid for by people who join a union for purposes of expressive associational activity. When you join a union, one of the things that you do is decide we can do better bargaining as a group and get better working conditions, improve the conditions of all people represented by the union, do something about the growing income inequality gap, provide better services or better products to the people who are the customers of the employer. All of this is important First Amendment activity that union members have to subsidize in right-to-work states for those who choose to free ride. Now, the law in this area, long series of Supreme Court cases that developed this whole system that I've just described to you. When public sector unions began to form, the first was Wisconsin in 1959, they adopted a pattern based on the system that had long existed in the private sector under the Railway Labor Act for railway and airline employees, and for everybody else under the National Labor Relations Act, also known as the Wagner Act, which adopted this whole membership regime. In a 1977 case called Abood, the Supreme Court upheld the constitutionality of a provision in Michigan law which required people who choose not to be members to pay their fair share of the union's representation costs. Because at the time, Michigan was not a right-to-work state, and so therefore, the public sector employer and the union could agree to require employees who were represented by the union to pay their fair share of the union's germane activities. There are a whole slew of cases following on Abood in the public sector and also similar cases in the private sector, as I've said, trying to draw the line between activities that are germane and activities that are not germane. The one I want to flag for you is a case called Leonard, decided in 1991, which tried to define the circumstances in which, or the line between activities that unions could charge their non-members for and those that they could not charge non-members for because they were not germane to the union's role of representative, and to charge them for it would violate the First Amendment rights of the non-members. And in that case, and this is why I think it's significant, Justice Scalia wrote a concurring opinion disagreeing with Justice Blackmun's majority opinion about the precise place that the line was drawn, but nevertheless recognizing that when a state chooses to govern its public sector labor relations by allowing its employees to unionize and making the union the exclusive representative, the state has an interest in not forcing the union to provide legal services on behalf of those who won't pay for it. So that was a fairly stable regime until a whole series of ballot measures in different states pushed by the National Right to Work Committee, the Chamber of Commerce, and business groups began to try to restrict what unions can do with respect to collecting dues from their members, with respect to collecting fees from their non-members. One of those was in California. I mean, these pop up on the ballot all the time. They try and restrict the use of the payroll system as a way of collecting dues so that the union actually has to go around and get cash each week or get people to do bank drafts on an automatic basis. One of those cases was Davenport, which was decided by the Supreme Court in 2007, which was a case in which a ballot measure tried to restrict the ability of the union to collect, public sector unions in California, to collect fees and dues from non-members. The unions in that case argued that the restriction violated the unions and their members' rights to spend money on politics, and the Supreme Court rejected the contention, essentially saying, the union isn't spending its own money, it's spending other people's money, so therefore a restriction on how unions raise money to engage in political activity doesn't violate the First Amendment. In Knox, a Supreme Court case decided in 2012, the court again dealt with a situation involving the collection of agency fees. Sorry, Davenport was a Washington case. Knox was a California case, having to do with, again, sort of these technical issues about collecting dues. And what Knox would have done is what the ballot measure in California would have done in Knox was essentially turn California into a right-to-work state. The court, there was a constitutional challenge. So I'm out of time, so I'm trying to condense a bunch of really complicated stuff into a really short explication. But essentially where we were up until the court granted review in Harris is that states can choose whether to be a right-to-work state or not. Even in non-right-to-work states, non-members cannot be compelled to pay for unions' ideological activities, and that's where we were until Harris came along. And so Harris is Scott's case, and he's going to talk about that case.
Scott, so why do we have Harris?
Thank you. I know the audience is probably divided between labor lawyers who are sick of hearing about Harris and non-labor lawyers who can't understand why Harris is a big deal at all. So I'm going to be brief, especially since we don't have a decision. But let me start with who the workers are in Harris. The main claim in Harris involves a group of 27,000 home care workers in Illinois who are paid by the state to care for disabled individuals in their homes because it's much, much less expensive for the state than paying for institutional care. And this arrangement has become typical. Public programs that pay for home care workers to deliver services in people's homes, and hundreds of thousands of workers are doing this type of work, and it's a fast-growing occupation. And if one cares about income inequality, one needs to look at what are the occupations of the future, what are people actually doing, and home care or child care or other home-based services are the growth field of the future. These are workers who were being paid an hourly wage by the state to provide home care. They wanted to organize and form a union to negotiate with the state. They're selected and supervised on a day-to-day basis by the disabled individuals they serve, but all the economic terms of their employment are governed by the state. The state sets their wages. The state approves a task list of the hours they have to work and what they're supposed to do. If they're ever going to get any type of benefits, they're going to get it from the state. Illinois changed its law in 2003 to bring these workers within Illinois' established Public Labor Relations Act that follows the model that Catherine described, where the majority of workers can choose to have a union, and if they do, they can engage in collective bargaining. These workers chose to have a union. They've negotiated 3 collective bargaining agreements. They've gone from earning $7 an hour before they were able to unionize to $13 an hour. They have a health benefits fund. They have a grievance procedure. The state provides them with protective gloves. They get a paid orientation. They get the things that workers want that make the occupation more attractive in a low-wage field. The state, for its part, gets someone to deal with, to try to make a deal for an occupation that is subject to incredibly high turnover, in which the state doesn't have just money to throw at the workers. The state has someone on the other side of the table to negotiate with, and the system was working. Under Illinois law, collective bargaining agreements can have fair share provisions so that workers who don't want to be part of the union have to pay for the representational activities of the union. It's automatically deducted from the paychecks that the state gives to the workers. The claim of the plaintiffs in the Harris case was that the deduction from their wages to fund the union's representational activities to negotiate the collective bargaining agreement to process grievances violated the First Amendment. They acknowledged that the issue had already been decided by the Supreme Court in Abood and about 10 other cases, but they said that those workers in Abood were teachers. The other cases involved people who were true public employees. We, the home care workers, were not really public employees. We're really employees of the disabled individuals. It's true, we get these paychecks from the state, and they deduct taxes from us, and we have to do what the state says, but we're not really public employees. The state doesn't really have an interest in this collective bargaining system, and this is a big impingement on our First Amendment rights that should trigger strict scrutiny, and the state doesn't have a compelling interest to justify us having to pay for this. They lost in the lower courts. The district court said, look, you're really public employees. The state's controlling this relationship. This isn't anything new. They lost in the Seventh Circuit. The Seventh Circuit said, you know, looking at the relationship, the state is really your joint employer. It's retained control over the employment relationship. Look at the collective bargaining agreement. The state's controlling all this stuff. The state has an interest in a stable system. This really isn't anything new. You have to pay for the representational expenses. You're not claiming they're charging you for political expenses. Supreme Court is now granted review, and the plaintiffs are asking the Supreme Court not only to rule that there's some difference between them and what would be regarded as more traditional public employees who work in common workplaces rather than people's homes, but to go back and overturn the entire line of cases that allows unions to charge for representational activities, to say that that triggers strict scrutiny when a public employer requires that. And doctrinally, that's a radical argument. You look at a case the Supreme Court decided yesterday, Lane v. Franks. Public employer fired a worker for testifying truthfully under oath about a matter of public concern when testifying was not part of the employee's job. Did the Supreme Court say that the government had to satisfy strict scrutiny to do that? No, that wasn't a strict scrutiny case. The Supreme Court said, well, public employers are entitled to manage their operations. We apply a deferential test that considers whether the government has a legitimate interest in its personnel system. Said, well, here the government hasn't articulated any interest at all in its personnel system. Therefore, the employee wins. But that wasn't a strict scrutiny case. And none of the public employee discipline cases are strict scrutiny cases. When the government retaliates against an employee for affirmatively engaging in speech at a city council meeting, the government doesn't have to satisfy strict scrutiny. But the plaintiff's argument is the deduction of a small amount from the wages the government is paying to the worker to pay for the government's created collective bargaining system, that somehow triggers strict scrutiny under the First Amendment and requires the government to show a compelling interest. And since half the states operate under right-to-work systems, they argue, the government doesn't need to do this, and therefore this entire scheme is invalid.
Scott, may I ask a question? So just to clarify that point, so you're saying that this is a straightforward coerced speech, coerced association case on the other side, right? They cite the Boy Scouts case in their briefs, right? Saying that you require me to pay, it's like requiring the Boy Scouts to accept somebody they don't want to accept as a scoutmaster into their association by government fiat. So it's like the Pledge of Allegiance cases or the Boy Scouts cases.
Yes,
in their view.
It's the same level of First Amendment impingement as if you made somebody stand up and say the Pledge of Allegiance out of their own mouth is the deduction of money to pay for the union's representational activities. That's the same First Amendment burden and the same test the government would need to meet. So let me segue and wind up with what are possible outcomes of the Harris case. Well, the Supreme Court could do what the plaintiffs want and overrule Abood and the entire line of precedents and hold that unions cannot collect fair share fees from the workers the unions are required to represent. And as Catherine said, that's a big problem because the government has created a big free rider problem. Unions can't bargain better wages and benefits for their own members. They can't represent only their own members in grievances. So from an economic perspective, you would be a chump to pay the union because you can get the same thing for free. And if you do pay for the union, you're going to be subsidizing all the free riders who don't want to pay for the services they're getting. So that's a possibility, and in fact, the implication of the plaintiff's argument, as they have asserted, is that even exclusive representation systems with no fair share fee violate the First Amendment, because they assert it involves designating a representative for the whole unit, and they view that as a form of compelled association, even though they don't have to be members of the union. And they already have filed cases elsewhere in the country arguing that exclusive representation, even without fair share fees, is a violation of the First Amendment. Another possibility in Harris is that the Supreme Court says we're not going to go back and revisit the line of precedents that have allowed fair share fees for public employees, but there's some difference between this group of workers and more traditional public employees. Or perhaps another possibility would be that it's okay as to this group of workers because this particular group of home care workers, they're enough like public employees, but that somewhere in the First Amendment, there's some test of employment status that limits the ability of states to extend labor relations systems to workers providing home-based services if certain factors aren't present that would spark a wave of litigation around the country. Some cases have already been filed about whether particular arrangements violate the First Amendment, and create a tension between a model in which the state can allow consumers to choose their own providers and a model in which the state can control the economic terms of employment through collective bargaining. They'd essentially force the states to choose that if you delegate too much authority to consumers to direct their care, you lose the ability to create a stable system of collective bargaining with the home care workforce. So those are potential bad outcomes in Harris that could have big ramifications either for public employees generally or for workers who are doing non-traditional public employee jobs who lack some attribute of the more traditional public employee who's working in a common workplace with a state supervisor. And that's why labor lawyers are very concerned about the Harris decision.
Thank you, Scott. And Nicole, talk some more about the possible implications.
Thank you. You know, I think when Scott described this case as being about income inequality, that's exactly right. It's about income inequality, it's about racial equity, it's about women's rights, and it's about rights of people with disabilities and the elderly in our country. This mechanism of allowing people to remain in their homes and be cared for by the care provider of their choice has been advocated for by states in order to save money, and it's great public policy, by people with disabilities and the elderly community of folks who want to be able to remain in their homes and not be placed into institutions, and also by workers' rights organizations that want to raise people that are providing some of the hardest work you can imagine for some of the lowest wages, to be able to raise those folks out of poverty. If you know anyone who does home care or has a home care provider, then you know that this work is difficult physically and emotionally. Physically leading to many injuries on the job because of lifting and moving individuals, but emotionally because the work is incredibly isolated. This workforce is about 90% female, it's majority minority, and for the most part, the workers in our units, we represent over 500,000 workers in this workforce, and there are millions of people providing this care in this country. These workers are themselves, for the most part, caring for people living in poverty and living in poverty themselves. Before unionization of this workforce, and we began organizing home care workers, SEIU began organizing home care workers in the 1980s, this workforce was basically invisible. It's dispersed, each person in their own, working in a separate home. So in the case of the Illinois unit, there's 27,000 workers in 27,000 different workplaces. The workers were powerless. They had essentially no clear employer, so no one to bargain with for the terms and conditions of their employment. And they had no collective bargaining rights. And through unionization, as Scott mentioned, home care workers were able to unite and build power. There were 6 states, interestingly, 6 different states joined an amicus brief filed in the Supreme Court supporting the right of the state of Illinois, and Illinois is also defendant in this case. I think the Quinn, and Harris v. Quinn, is the governor of Illinois, and it's important to note that the state attorney generals from 6 states with similar models filed a brief arguing for the importance of this model for their state and for the citizens of their state. And they argued the importance of the model not only to save the vast millions of dollars that they're saving, but also in order to allow people the dignity of remaining at home and of increasing the standards, the work standards for this workforce, so as to increase the supply of workers, to reduce turnover, to increase quality of care, and to also allow for the states to have better retention and recruitment. So these home care collective bargaining systems that are really at risk in this case, and I'll talk more about why they're so at risk because of this case, have allowed people with disabilities to stay in their homes. They've allowed this majority female and minority workforce to raise itself out of poverty, and really has allowed this workforce to emerge from the shadows. So why is the risk to a fair share provision in these collective bargaining agreements such a risk to the power of the union? In the typical workforce where workers are all together in a single building, one can imagine going around and talking to everyone about collecting union dues. And in fact, in right-to-work states where fair share fees where states are not permitted to negotiate a fair share fee in a collective bargaining agreement, that's indeed what unions have to do. Go around and talk to each person about the importance of the union and sign them up as members. In the case of home care workers, where each individual is in a separate workplace and where there are privacy concerns about going to that person's home, because indeed they're caring for somebody in the home who is a patient, there are HIPAA concerns, it's a Medicaid patient. So in the case of these workers, it's difficult and sometimes nearly impossible to reach that person and talk to them about the union. Not to mention language barriers, et cetera. In our unit, I know that in our home care unit in Los Angeles, where we represent, I believe now about 125,000 home care workers in the county, our union meetings are translated into scores of languages because of all of the different languages that this workforce speaks in LA County alone. So without the ability to collect fair share fees as a matter of law, and with the difficulty of collecting union dues and signing people up as union members, the ability of the union to negotiate a strong collective bargaining agreement and to advocate for the workers it represents is vastly diminished. Both the prior speaker spoke about the free rider problem, and interestingly, Justice Scalia at oral argument spoke at length actually about the free rider problem, which is why I think many of those of us who were at the argument or heard the argument hold out some hope that Justice Scalia will do the right thing and affirm prior precedent in this case. Without the ability to collect
So the
those,
fate of unions in this country depend on Antonin Scalia?
Indeed.
Is that what you're saying?
Perhaps. There may be others. Yeah, it's never really a great day when that's what you have to say. But the fees really cover, the fees that are charged cover the cost, as mentioned, of negotiating and administering the contract, but also allows the union to do so in a way that is strong and robust and advocate for members. So what's at risk? I was asked to talk about what's at risk. What's at risk is a strong and robust union for home care workers throughout the country. In the states where home care workers already have a union, the hundreds of thousands of home care workers that are represented by a union are now at risk of losing a strong union and of a huge free rider problem and a problem with enrollment in a workforce that's dispersed and with incredibly high turnover as well. In terms of, certainly in terms of public sector unions generally, were the court to decide that fair share fees are are considered unconstitutional, not only with respect to this particular workforce, but with respect to public sector unions generally. Those who follow the issue know that union density has dropped dramatically over the past 30 years, whereas in the 80s, it was somewhere around nationwide in the 25%, I believe. Now, overall, nationally, union density is around 11%. In the private sector, we're now below 7%, but in the public sector, that's where union density is strong. And so this case really, I think it's not a coincidence that it targets the fastest growing workforce in America, that it targets among the lowest income workers in America, but also that it targets the place where unions do have the highest number of members, continuing today, upwards of 35%. And I wanted to close just with a comment that I was, when I was thinking about what Cheryl was saying about judicial activism, for those of you who were at the fabulous opening plenary, where she talked about cases where the court reaches out and takes a cert on an issue where there's no split in the circuits. What Scott didn't mention is that this case was filed in 2010, am I correct? Originally. The Seventh Circuit ruled in 2012, and the cert petition was filed 2 years before cert was granted. There was no split in the circuit. The Seventh Circuit panel was unanimous. There was 40 years of precedent. The cert petition was conferenced 8 times, which I also believe is an unprecedented number of conferences. And suddenly, last fall, cert was granted, and oddly and coincidentally, cert was granted only about a week after the Eighth Circuit had stayed a decision of a district court in a very similar case on the basis that cert was pending in Harris v. Quinn. All of this was a very odd, for the sort of all of us being geeky lawyers in the room that like to follow kind of quirky legal procedural issues. It was an example. When Cheryl was speaking on the opening plenary and giving this example of reaching out and taking an issue that where there's no split in the circuits and was not really presented to the court. Harris, I was sort of surprised that she didn't give the example of Harris, because there could be really no more prime example of that in front of the court today.
Sarita, so hearing the other speakers, I wanted you to talk about the even more implications, but in particular about how does this fit into the broader attack on unions, and particularly public sector unions that we're experiencing in the country today?
Mm-hmm. Thanks, Ken. So first of all, it's great to be here, and I should start by saying I'm probably the one person who isn't a lawyer on this panel. My name is Sarita Gupta. I'm the Executive Director of Jobs with Justice, and the work of Jobs with Justice is to protect and expand the right to organize and collectively bargain for workers. A large part of the work we do is to think about how we can help support creative organizing of workers, and how we can shape the public discourse on workers and the economy as a whole. And so that is a backdrop just to say this has been a really important case that we've been following. And as we've heard today, it's possible that the Supreme Court may take away collective bargaining rights of all public sector workers. It's much more likely, though, that an adverse ruling will mean the loss of collective bargaining rights for home care workers. So I want to hone in on that a bit and then build back out. When we think about the impact of such a decision on organizing, we should separate the legal from the practical. Yes, it may be that home care workers lose the right to organize as a formal labor organization under state laws with the ability to compel bargaining. And yes, the loss of that right would be a painful blow for workers' rights, at least in the interim. But that doesn't mean that brave workers will stop organizing and influencing their working conditions. It's important to recognize that unions like SEIU and AFSCME brought home care workers together in the past before they had the legal right to formally organize, as Linda mentioned. And While the law in a post-Harris v. Quinn world may not technically recognize unions as the certified exclusive representatives of home care workers within the ability to compel the state to bargain, they can still sustain and build out organizations of these workers. These organizations can put political pressure on the state to do what is right, which is listen to the voices of home care workers, provide fair compensation rates, and offer access to training. Doing so may mean more work and certainly costs for the union, at least initially, but a bad Harris versus Quinn decision won't end organizing. It won't stop continued alliance building between providers and consumers of care who will keep demanding more public investment in creating affordable, accessible home care and child care. If I've learned anything from spending time with home care workers, most of them who are these incredibly fierce women, and women of color in particular, it is that a bad Supreme Court decision won't silence their voices. That's a fact that the National Right to Work Committee and other opponents of workers' rights who bring lawsuits can't seem to grasp. Home care workers and their supporters are fighting to be heard so they can live a life with basic dignity in today's economy. They will not quit. And just to say, in this moment, as we celebrate the 50th anniversary of the signing of the Civil Rights Act, we're reminded that those fighting for justice, whether it be at a lunch counter or in a workplace, don't just quit. So having said that, let's talk about what the opportunities are from an organizing perspective. As Scott mentioned, home care is one of the occupations of the future. We have been really fortunate in thinking about a creative organizing campaign with SEIU and AFSCME, and it's worth saying that there's a growth of home care workers that are domestic workers in private homes were workers who were hired to be nannies and housekeepers, but suddenly were being asked to provide elder care or care for disabled people without any kind of real training or supports. And that's sort of what led us to launch a campaign called Caring Across Generations. You see, we need innovative movement building campaigns that change the political climate for us to begin to think about how we, in fact, expand the right to organize for workers in the home care industry. Caring Across Generations is a movement that brings together aging Americans, people with disabilities, in-home care workers, and their families to protect all Americans' right to choose the care they need and to advocate for a system of quality, dignified care. Why does this matter right now? Well, this effort is rooted in a very deep appreciation of demographic shifts facing our nation, and within this lies an enormous opportunity. We are a rapidly aging nation, with people living much longer lives. As a nation, we are aging. So one person in the baby boom generation turns 65 every 8 seconds. That's 10,000 people a day, 4 million people a year. More than 70% of individuals aged 65 or older will require some form of long-term services and supports at some point. The majority of Americans want to be able to remain in their homes as they age. And for more consumers, it's much more cost-effective to have in-home care than to have to pay for care in an institutional setting. Yet the great expense of long-term care makes it unaffordable for Americans at almost every income level. We know people with long-term care supports and service needs are projected to grow from 13 million in 2000 to 27 million in the year 2050. Yet the current direct care workforce numbers approximately 3 million workers, leaving a huge gap between the services that are needed and the workforce currently available to deliver those services. So you see within this creates an enormous opportunity to be creating new care jobs and to train workers to fill the care gap. And what we'll be needing to do is to make sure that the jobs that are created are in fact good jobs, that workers are in fact paid a living wage and receive decent benefits. So the issue of long-term care is actually impacting everyone. It's not just impacting the aging population. It's impacting many people in this room, I'm sure. For me, I'm a member of a sandwich generation. I have a father with Alzheimer's, and we're trying to figure out how to get the care he needs and deserves. But I also have a 4-year-old daughter who I have depended on home care workers to care for so I can work. There are many people like me who are sandwiched and trying to figure out, how do we best meet the needs, the care needs of our family members? The beauty of a campaign like Caring Across Generations is if you can tap into the hearts and minds of the public on this broader need for a new long-term care system, the opportunity for the union is to make sure workers are at the table from the beginning to shape what that new system looks like, to ensure that workers' rights are embedded into the system we create together. There's a lot of different ways in which this campaign is rolling out. We believe we need to build a caring majority, and within that, there's a strong pillar that's about workers' rights, the workers' rights to collectively bargain. And we can talk more about that in the discussion portion. But I wanted to lift that up because, again, workers are going to keep organizing. And so if we broaden from home care to public sector, that is also true. Workers are going to keep organizing. And within that, there's huge opportunities for us to think about in this aftermath. What are the different provisions and laws that we can be strengthening and expanding right now? So I just want to take a moment, and I think we might get into this in the discussion, but just to sort of plant a seed, that one of the areas that we're looking to in an aftermath of Harris v. Quinn is, how do we think about the opportunities around strengthening Section 7 of the National Labor Relations Act? And for folks who don't know what Section 7 is, it is a central element of U.S. labor law. It establishes the right of employees covered by the law to form unions, collectively bargain with their employer, and engage in concerted activity, i.e. strikes, over the terms and conditions of their work. So when we look at campaigns right now like our Walmart, or we look at fast food workers, or we look at home care workers and actions that they're taking, much of that work is protected and able to happen under Section 7. And I hope in the discussion period we can talk a little bit more about why that's so relevant today, given the changing nature of work today. We'll leave it at that, given time.
Thank you, thank you. Okay, so we've got some time for questions. If you want questions, please wait for the mic. Someone will bring you a microphone so we can get it recorded, and then you can suggest which panelist you address your question to.
I do this almost every year. My name is Eddie Eiches. I'm president of AFG Council 222. I represent workers at HUD in 40 different locals. And I just wanted to describe the model at the federal level, which is very, very different, and also a model under attack. We are paid by the federal government. My salary, once I get elected, I'm a federal worker, and I'm paid as a senior trial attorney because that's what I was. I could be paid as a secretary. It's all open shop. So we are required to represent people, everyone in the unit. And right now, this official time, so I have about 125 people around the country who sort of report to me in some fashion. So the Republicans now in the House have attempted to get rid of what is called official time, the way we're paid. And in fact, 2 weeks ago, there was some success by a Republican from Georgia in attaching the end of official time to an appropriations statute. We stopped that with a coalition of every Democrat and 60 Republicans. But again, this is a different model and a model also under attack. So we really do not need union dues to survive because we're being paid by the government, and the union dues, in fact, mainly go to pay our per capita to our national, to deal with national issues. In a lot of, we haven't talked much about the right to work states where public employees cannot, don't even have the right to collectively bargain. In those instances, you'll find AFT operations that have members, often large numbers of members, and will informally deal with all types of issues. But in fact, in those states, the only ones who who will get representation from AFT through the state-designed grievance process are the AFT members. So I just wanted to say that there are so many different models, and this is not the only model. And for sure, the model of in a state like Virginia of healthcare workers who can't even negotiate formally, even if they are paid for by the state through this.
But this is another iteration of a broader attack on unions and especially public
Exactly.
sector unions. Okay.
Thank you.
In the back there.
Hi, speaking of the
Could
broader...
you stand up,
Oh,
if you don't
sure.
mind, please? Just so we can see you.
Speaking of the broader attacks on public unions, and first of all, this is an excellent panel, one of the best panels I've been to on Harris v. Quinn, and I've been to many over the last several months, so thank you very much. I was wondering if someone could talk about the California teachers case that recently came out about the tenure law, and how that interacts with Harris v. Quinn or the larger attack, and what the implications might be. Thank you very much.
I think my office is doing that case too. Yeah, that it isn't fit in exactly legally with Harris v. Quinn in terms of the doctrine that's been raised, but it is part of a broader backlash against public employee unions that there's something illegitimate about them. In the Vergara case, the argument is that due process protections for teachers against dismissal violate the state constitutional right to an education because it's claimed they make it too hard to get rid of bad teachers. And I think the fact that even a trial court would take the argument seriously and grant judgment for the plaintiffs shows the backlash against public employee unions, in which what might have seemed obvious years ago, that legislatures have some discretion to adopt employment systems, including employment systems that provide for tenure and just cause dismissal, and the issue whether a particular system is too strong or too weak is really a legislative judgment. Years ago, it would seem like that would be obvious. To me, it's still obvious, but now the argument is made that, well, public employee unions, they're just too strong. They've captured our legislature, and the courts need to do something about it. That there's a need essentially for judicial activism to push back against public employee unions and the protections that they have negotiated. And I think it's part of what we see as a broader backlash, which includes a backlash against public employee pensions. That the feeling now seems to be that, well, yes, at one time it was true that you could work and have a job and retire and have a good pension, but we can't afford that anymore. That's not, the United States now, where people could have good pensions, and that the public employee unions are obstacles to getting rid of the current pension system, and therefore the court should step in and figure out a way to weaken the unions. So I'm going to predict that the Vergara case will ultimately get reversed on appeal, because I don't think that there really is a significant connection between just cause protection for teachers and the problems in our school system in California. But it is part of the backlash against unions.
So in fact, if I can just take a second, I think if we look at this case, the Harris case and the teachers union case, in a broader, even a broader spectrum, we can even have cause for even greater worry, right? Because I think some of the most innovative and creative litigants in constitutional law today are corporations, right? And I'm not just talking about Citizens United and Hobby Lobby. I'm talking about cases that are restricting workers' rights to raise class actions, right? We're talking about the court's decision to protect corporations from claims about violations of human rights. We're talking about restrictions on securities fraud cases, right? We're talking about the expansion, the unprecedented expansion of commercial speech doctrine to cover things about whether pharmacies can have a right to sell the private data of their customers. So I think if we have, and the Chamber of Commerce, by the way, had a 78% success rate last term. This is an incredibly pro-business court, this Roberts Court, and this is just one point in a scatter plot that is pretty problematic. Mm-hmm. We had another question over here on the corner, on the side. Right, the gentleman here on the far end. And we've got about 15 minutes left, so
And this is about a 15-second question. First, Rita Gupta, you mentioned that one thing to look at, of course, is Section 7, but there are other measures that also could be expanded in terms of labor law. I'm thinking of things like, although the lower courts threw it out several years ago, using California's spending power to basically level the playing field. That's just one example. Talk about some of the others.
Yeah, thanks for that. Yeah, I just think in this moment of income inequality, we are seeing workers rise up. We are, and we know that our labor law is weak and broken in many regards. Where it works, where it doesn't, it really doesn't. And so workers are having to navigate how to get around the law in order to continue to protect their wages and working conditions. And so I lifted up, I do want to take a second to talk about the need, this moment, and the need to strengthen Section 7 of the NLRA, because I think people forget that the Section 7 impacts more than unionized workforces. It impacts all workers. And so, today, especially when we see such a huge changing nature of work playing out before us, the growth of contingent work today, the growth of part-time, temporary, subcontracted workers, these are workers who are falling through the cracks, yet it's close to a third of our workforce are working contingent labor today, right? So workers find themselves in these elaborate subcontracting schemes where they may be doing things like moving products, for Walmart in a warehouse owned by a logistics firm while receiving a paycheck from a staffing agency. Or in a place like Tennessee where workers do the same job on a Nissan assembly line but receive different pay and benefits depending on if they're employed by the automaker directly or by a temp agency. Still, other workers, like FedEx ground workers, wear a company uniform and drive a truck with the company's logo, but are told that they are independent contractors with no employment rights, right? So how do we ensure that these workers, effectively denied Section 7 rights, have protections to engage in collective action, particularly as union organizing in most private sector remains so difficult under the broken law? So I think the work that we're seeing, whether it's our Walmart and the Walmart Associates, the membership association building and developing and striking, really taking advantage of their Section 7 rights to strike on Black Friday, or if we see restaurant workers who are taking actions around paid sick days and ensuring they aren't being retaliated against, or fast food workers who are striking. Many of us have been a part of walkbacks into this franchise, the stores themselves, the fast food restaurants, to make sure they are not retaliated against for striking. So these are the kinds of innovations and organizing that are happening, and we need to figure out how we continue to strengthen and expand Section 7 of the NLRA. I think in addition to that, there's a lot of good creativity playing out right now, thinking through other ways we can be expanding and extracting power and laws. Like right now, when I think about at the city level or in labor markets, for example, part of the question we're grappling with is how do we literally expand the theater for organizing? How do we expand the theater for organizing so that workers and community can in fact confront corporate power in different and new ways? Because that's what's required now. And so there's all kinds of interesting campaigns that are starting to take shape. We're doing a campaign in San Francisco that's a Retail Workers' Bill of Rights that's looking to increase the minimum wage, coupled with just hours provisions, coupled with lots of wages and hour provisions that allow us to actually open up the space for bargaining beyond the traditional ways in which we think about bargaining. And a piece that we are testing out is a thing called the bad business fee. We might end up calling it the fair share fee. But the bad business fee, which basically would say to employers, if you aren't willing to negotiate with workers on wages and working conditions, then we will create a public authority that can extract a fee from you, a tax, if you will, from you. And that money can be pooled into some sort of supporting wage subsidies or important services that low-wage workers need. The reason that's so important in this conversation is it literally puts bargaining into a public sphere, which I think we need to do more of in this moment to make sure we're actually expanding the sphere within which we're testing out new legal frameworks, which frankly, we need new legal frameworks right now. But none of that is possible without continuing to organize and change the political will for those new legal frameworks to come into fruition. So.
I'm sorry, this gentleman had his hand up first, and then.
Thank you. I'm Bob Weinberg. I happen to be a member of SEIU, since SEIU has successfully organized adjunct faculty members at law schools and universities in this area. My question relates, though, to what are the implications that bar organizations, compulsory membership bar organizations that most states have, what are the implications for them of the First Amendment issues pending before the Supreme Court in the union cases? By and large, a bood had been applied to compulsory state bar organizations, limiting what they can do beyond
Right.
the areas that the core areas.
Catherine,
But is a bood likely to be overruled as applied to organizations other than unions as a result of the litigation you've been describing before the
Catherine,
Supreme
you
Court?
want to take that?
Sure, and I think Nicole might want to jump in too. I'm not sure that a bood is going to be overruled, and because I think it would be too radical, in part for exactly the reason that you suggest. When the court upheld the ability of an organization that represents a collective to charge everybody for the services that it provides, it has obvious implications for integrated bars that charge dues. And in Keller versus California State Bar, the Supreme Court rejected the argument that charging bar dues violates the First Amendment rights of bar members because it forces them to subsidize speech that they don't agree with, although it did suggest that there are, and hold indeed, that there are certain things that the bar cannot charge dues for, speech that's unrelated to the bar's function. The court has never been consistent in the way that it has treated levying fees on collectives for purposes of speech of the collective. So in Citizens United, recall one of the justifications for restricting corporate campaign contributions was to prevent shareholders whose views differ from that of the corporate executives who make decisions about political expenditures from having their share of the corporation's resources spent to subsidize speech that they disapprove of. The Supreme Court rejected the argument that protecting the dissenters within a corporation was a legitimate reason for restricting corporate speech, saying, look, you can't let the dissenters silence the majority. It's never applied, of course, that principle with respect to unions. With respect to student activity fees at public universities, in an opinion by Justice Kennedy and Southworth versus University of Wisconsin, the court upheld the levying of student activity fees over the objections of conservative students who didn't like some of the student organizations that got the funding, finding that in a university there is a legitimate interest in requiring everybody to support the speech. And so throughout this area of First Amendment there is always the interest of the majority within an organization in having the organization speak, and the minority who would prefer to prevent the organization from engaging in expressive activity that they disagree with. I don't think the Supreme Court is going to touch the ability of state bars to require dues, and is going to recognize, come on, they're lawyers, and is going to recognize that state bars have an interest, a compelling interest, or whatever their standard going to apply in this area. One of the things, building on what Sarita said, is that, of course, with respect to unions and worker activities, the First Amendment, I think, is a two-edged sword. It is true that the court has conceptualized the right of public employees to not support the union's political activities. If only government employees had such power under the Hatch Act, where, of course, government employees lose their right to engage in any partisan political activity, full stop. Forget spending money. It's just bumper stickers and the rest of it. There is always this question, though, of how are you going to balance the right of the majority and the right of the minority. And the only sort of bright spot I can see in the Supreme Court's expansion of the First Amendment rights of collectives like corporations to engage in speech, or the rights of the Boy Scouts to discriminate in membership against gay scouts, is that there is a possibility that workers can use some of this bad First Amendment law that's fundamentally deregulatory to say, okay, look, we want to engage in speech activity. We want to picket.
That's right.
That is First Amendment conduct of the primary sort. And in fact, I predict in the abortion protest case, the McCullen versus Coakley case from Massachusetts, if the court reaches a result that says Massachusetts cannot have a buffer zone around clinics in order to protect people who provide reproductive health services and people who are seeking reproductive health services, including abortions, then I think that the ability of federal law to prohibit picketing and protest is clearly unconstitutional, and it's time to take that on. So the First Amendment is a two-edged sword. It protects collectives, it can protect dissenters, and I think the court has to be forced to be more consistent in allowing the First Amendment to protect the right of association and union speech, as well as the right of union dissenters.
Do you want to say something? We've got about 3 minutes left. Did you want to say something?
Yeah, you're not going to take another question? No. Well, I wanted to follow on Sarita's eloquent description of what's happening in the field and say that the members of our union and home care workers around the country are really inspired by these fights for $15 an hour for fast food workers and the fights of Walmart workers. And we've been spending, really since CERT was granted in Harris, we've been talking to our members about the threat on their union, and they're inspired to do work regardless of what the court decides. They want to join together. Our home care members want to join together with non-union home care workers, not only in the states where they're organized, but throughout the country, and really form a home care dignity movement that will also fight for 15, because they're not there yet either. And because it's the fastest growing job in America, and because there is such a need, and really such incredibly compassionate work that they're engaged in, the case itself has inspired us to go forward and organize in new ways, and to bring them together together forward in this fight, regardless of what happens next week. And it's really a week.
Yep. So we're going to wrap up. I've got a couple of final points. One is I think as we watch next week to see what will happen, be mindful of the broader trend. We may be in a new Lochner era, where the work that's being done by the court is not by way of the Due Process Clause so much, but by the First Amendment, right? And the First Amendment is going to be used as a weapon on behalf of those anti-union or pro-business to fight, to really change the economic understandings in America today. The second thing that I want to say is I want to recognize Deepal Shah, who has been instrumental in not only this panel, but a lot of the work of the ACS for several years now. And he's leaving ACS at the end of this month to take a position at the de Blasio administration in New York City. And the reason I want to say this publicly is because I think ACS often is focused, has been traditionally focused on sort of pointy-headed con law types, right? But it needs to expand a little bit to those of us who are concerned about economic rights and labor and environmental law and tax and corporate law even. And Depot has been an advocate as a staff member for that move. And I just want to say thank you for this, what you've done for this panel, but also in general.